Assalamualaikum and a very good day for you guys. So today my team and I will be presenting the test administration. So let's proceed without time. So the scenario of the problem in this case of the test administration is Dr. Ariel is a medical officer at the HUKM since 2015. So his salary is 3,000 per month. So the problem is Dr. Ariel didn't pay any income tax since the beginning of his work until now. Dr. Ariel also further his study in UKM and then he gained 4,500 per month. Since he worked 2015, he never filed up any return and pay an income tax as what I said before. So he was shocked when he received a notice from the IRB asking him to pay the penalties due to his offence that is failure to furnish the return under section 77 subsection 1 of ITA 1967. So Dr. Ariel has a friend, Kamal. Kamal is a person who worked with the IRB as a tax officer. So he explained to Dr. Ariel about the self-assessment system, which is SAS, but Dr. Ariel become confused because he never hear anything about SAS. So he then asked Kamal to explain step by step on how to comply with the system, which is SAS. Okay, so let's proceed. So first thing first, I want to ask you guys, why do we need to pay tax actually? What is the function of tax? Okay, first thing first, tax. If we pay tax to the government can pay the salary of the government workers. So that's why we will find that the government workers will do their job and the salary paid to them is from based on our income tax and also other tax. So the second thing is we pay tax because we need to provide revenues for the government. The government will generate the revenues from the income tax that we pay to them. So, and the last thing is, one of the thing is to support the common resources such as police and also firefighters. Who else will pay the firefighters and also police if not the government? So where will the government get the money if not from us, which we pay the income tax? So that's why we need to pay tax. You must pay the tax. Okay, first and then okay, return and assessment. So what is a return and assessment actually? So return assessment states that individual who is liable in Malaysia is required to pay the tax at the IRBM. Okay, let's say now I have an income of some amount of money. So if I was liable to be pay the tax, so I need to pay the tax as IRBM, which is we usually known as the LHDN, Lembaga Hasil Dalam Negeri. So in return and assessment state that individual who is liable has to pay the tax. Okay, and then to pay the tax we have to file the return using the form B for the resident who carry on the business and other income, and for those who does not have business, he must file the form BE. And for the non-resident is if the person has the business, so he must file the return form, which is form M. And for those who does not have business, so he must file form MT. So this is what we call return and assessment for simplified. So we live in an era of modern technology, right? So we are in 2019, and if there is still some people that said I don't have any time to go to the IRBM because I am so busy with my work. So this is not suitable for us to use reason to not pay income tax because there is e-filing. Right now we are living in a modern era technology. So IRBM also provided us with the e-filing where we can pay income tax by online method. So all you need to do is go to the IRBM website and register your details. So this will ease you to pay the income tax. And then, okay, filing of return. Filing of return. What is filing of return? Under Section 77, Subsection 1 ITA 1967 states that for each year assessment, every person should provide to the DG a return of Form B where there is due date that has been set. So if we make payment of the income tax, we need to submit the Form B or Form BE to the DG, which is Director General. So before a certain date, which is if the person have business income, so he must submit the return form not later than 30 June. And otherwise, if he or she does not have business income, only employment income or other income, he or she must submit the return not later than 30 April. So you must make sure that you file the return form before this date, because if you don't file the return form before this date, you will be imposed some penalties and you must pay some additional charge. Okay.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Anas. So I would like to tell about the self-assessment system, which is the system that have been introduced to the employee to make the employee to have the responsibility, to give the responsibility to the employee to register their income to the Inland Revenue Board, which is IRB. So first, which is what is self-assessment system? First, the taxpayer had given the responsibility to assess themselves on the income they have received accrued to calculate their income tax. Second, taxpayer also have the responsibility their own tax liability with limited or even intervention. And lastly, responsibility had changed because we have taxpayer to make proper account, assessment and payment to their income tax. So, based on this meaning, which is the IRB has given to us, which is the employee to take the key in ourselves, to key in the return form by ourselves, to tell the IRB which is how much we need to pay the income tax and to get some relief that government can give to us. So next is responsibility of taxpayers under self-assessment system, which is first, taxpayer must keep the required books and record for support the returns and make sure that assessment is correct. So the taxpayer must keep required books. So which is, if we want some relief, we must keep some receipt, or we need to save, which is for example, I give one example is medical relief. So if we want the amount that we want to relieve, we need to keep the receipt that we have buy the medical. So if the IRB come to audit us, so they can see the receipt. Second is, if the taxpayer will be audited, they must keep the books record and must follow the instruction of auditing. And last, make sure the returns file on and make payment to IRD by the due dates. So the employee must pay the income tax due to the IRD in the date that IRD said. There is type of assessment, which is have two types. Which first is self-assessment for companies, limited liabilities, partnership, trust bodies or cooperative societies. And second is individual assessment. Okay, next. Qualification to be liable for tax income. First, which is the first, from 1st January until 31st December each year, Malaysia's personal income tax will be assessed. Second, salary above 30,000 ringgit will liable with the tax. So which is I think if we fresh graduate, we don't need to pay tax because we only get I think almost 2,200. So which is if we have the high of the high what we call high stage of the growth, we can get more salary, so we need to pay tax. And then third, if taxpayer not pay the tax after receive letter from IRB which is 30 April on the tax on the next year, for person that not carry any business will be charged 10% additional for unpaid tax, which is if the taxpayer if the IRB had sent the letter to the employee's house, so the taxpayer must pay the tax within the date is the next year before 30 April. So if the taxpayer late pay the tax, so he can be discharged by 10% additional for unpaid tax. Okay, and lastly, person that have income more than 34,000 after EPF deduction will be liable to pay tax, which is this is person that have income more than 34,000, which is the person have annual. So in the year, if we calculate their salary after deduction of EPF, we get 34,000 and above, so he need to pay tax. Next. Okay. Actually, as we know, Dr. Ariel in the question said that Dr. Ariel have problem to pay the tax, which is he don't know how to register about the tax, and he asked Kamal to tell him about the solution. So in the question, let's say us is the Kamal, and I have a method that can be solved to him. First, if Dr. Aris first method is the Dr. Aris does not register yet. So first, Dr. Aris employer had registered the assessment in Inland Revenue Board. So if he has registered, he just need to pay penalties that IRB has calculated for him at the IRB branch nearby his house. And second, company that Dr. Ariel work will issue the income for each of the year, and the employee or Dr. Ariel will able to declare at IRB their annual income after receive the letter from IRB. And then third, Dr. Ariel must fill in the BE form and go to IBM branch to pay tax. So every year, the IRB will give the BE form. So we can update about our relief and then update about what we have got in income. So IBM will take note and will calculate for us tax, and we need to pay. We just need to pay. And then fourth, Dr. Ariel also can pay online if he does not have time. As we know, Dr. Ariel is a doctor, right? So more patient will come to him and he may not have time, so he can pay online, which is www.tinnsdi.com. So, and follow the website of instruction of the website. And second last, Dr. Ariel must complete the BE form and declare for every year to IRB, and every time he receive the letter from IRB. So it is every time he receive the IRB, he need to fill in the BE form. And last, Dr. Ariel can avoid being penalty again by pay the tax before 30 April in the following year. So he need to pay the tax before 30 April because he is not carrying the business, but he is an employee. So that's all.
Yeah. Okay, so next is scheduler tax deduction system. So this system, also known as potongan cukai bulanan (PCB) in Malay, is a collection whereby it is obligatory for each employer to deduct their employee salary each month. So this is schedule determined by lembaga hasil dalam negeri for payment income tax of the employment. This effect is effective from 1 January 1995. Okay, so next is scheduler tax deduction system. So this system, also known as potongan cukai bulanan (PCB) in Malay, is a collection whereby it is obligatory for each employer to deduct their employee salary each month. So this is schedule determined by lembaga hasil dalam negeri for payment income tax of the employment. This effect is effective from 1 January 1995. Based on the system, the employer will take sum of income of the employee into the yang tak ambil awal tu. This effect is effective from 1 January 1995. Based on the system, the employee will take into the account of the employee monthly remuneration to ascertain the monthly tax deduction. Monthly tax deduction is provided by the tax authorities. So based on section 13 subsection 1, remuneration that was paid during the month will be subject to scheduled tax deduction. For example, the employee's salary, allowance, overtime and commission and bonus will be deducted from their income tax, for their income tax. Any kind of benefits such as car, fuel and accommodation will be excluded. So to determine the tax deduction, the amount of tax deduction will depend on the following factor. The employee monthly income is minimum of 3,000 per month. The number of their children, working status of wife and contribution to EPF fund or any approved pension fund. So next is this is the monthly tax deduction table, which is the income range we can see from 2005 until 50,000. So based on this situation, Dr. Egel, since his income is 33,000, he should pay his income tax and he is liable to the tax. So Dr. Egel income will be deducted from with their monthly tax deduction table.
Assalamualaikum. So today I will explain about penalties and fine in the tax income. So firstly, this is the table penalty and amount of fines that will be imposed to the person who did not pay the income tax. So there are a lot of offence that any person always do. So firstly, the offence failure to furnish an income tax return form. Provision under Income Tax Act 1967, Section 112, subsection 1. So amount of fines is Rm200 to 2,000 ringgit and can be imprisonment or both. Second is failure to give notice of chargeability to tax under Section 112, subsection 1. So dia punya amount of fine is same with the failure to furnish an income tax return form. Next, we move to make an incorrect tax return by omitting or understanding any income under Section 113, subsection A, subsection 1A. So the amount of fine is 1,000 ringgit to 10,000 ringgit and 200% of tax under charge. For the fourth, give any incorrect information in matter affecting the tax liability of a taxpayer or any other person. Meaning that the person give the correct information to the IRB. So this case under section 130 subsection 1B. So amount of fine is Rm 1,000 ringgit to 10,000 ringgit and 200% of tax under charge. Next, we move to willfully and with intent to evade or assist any other person to evade tax under section 140 subsection 1. Amount of fines is 1,000 ringgit to 20,000 ringgit or imprisonment or both and 300% of tax under charge. Next, assist or advise reasonable other to under declare the income. This section is 140 subsection 1A. The amount of fine is 2,000 ringgit to 20,000 ringgit and can be imprisonment or both. And we move to next offence. Attempt to leave the country without payment of tax under section 115 and subsection 1. Meaning that sometimes the person who didn't pay the income tax, so they cannot leave the country. So if they leave the country, they will be arrested by police or immigration because of didn't pay the income tax. So the amount of fine is 200 ringgit to 2,000 ringgit or can be imprisonment or both. And next we move to obstruct any authorized officer of IRBM in carrying out his duty. Under section 116, amount of fines is 1,000 to 10,000 and can be imprisonment or both. Next we move to fail to comply with an order to keep proper record and documentation. Under section 190 subsection A, amount of fine 300 ringgit to 10,000 ringgit, can be imprisonment or both. And the second last is fail to comply with a notice asking for certain information as required by IRBM. Under section 120 subsection 1, the amount of fine is 200 to 2,000 ringgit Malaysia and can be imprisonment or both. And lastly, if fail to give notice on charge of address within 3 months. Under section 120 subsection 1, amount of fine is 200 to 2,000 ringgit imprisonment or both. So as we know, in the Dr. Irel case, based on Dr. Irel case, he never fill up any return form and pay income tax since he started working on 2015 until 2020. So he failed to furnish a written form that more than 2 years of assessment, meaning that he never fill any form or pay income tax more than 2 years. So he will be charged under section 112 subsection 1A. As I said before, section 112 subsection A is failure to furnish a written form, meaning that it is a serious offence for non-submission of tax return for 2 continuous years of assessment or more. IRB would treat such non-compliance as fraud or willful default as criminal offence and empowered to exercise its best judgment and issue notice of additional assessment to enforce tax collection. Since the notice given by the IRB is with prosecution, so Dr. Ariel will be imposed penalty and amount of fine within RM 1,000 ringgit to RM 1,000 ringgit to RM 20,000 ringgit or 6 months imprisonment or both, plus penalty of 3 times the tax payable. So that's all from me. Thank you.
Okay, today I will talk part of tax income where the title is appeal. Okay, in section 99 of the Income Tax Act, a person entitled to appeal against that assessment. That means when you as a taxpayer send your statement to LHDN and they maybe make mistake on your assessment, or next case like if have some addition of your assessment, that this you should get, but the LHDN not put in your assessment. Okay, so The following cases not covered under this provision. First, assessment under section 90 subsection 1. Second, assessment under section 91A. Okay, section 99 applies only for any evaluation year for the following cases. First, assessment made by DJIR, or good assessment without ITRF, or we call as income tax return form, or late submission of ITRF person to subsection 19 subsection 3. Okay, there are two procedure to appeal. The first one is form Q, and next is form N. Okay, I will tell about form Q first. Form Q must, the appeal must submitting form Q no later than 30 days after receipt notice of appraisal. That means when you get the notice when you should make appeal, in 30 days you should send the form Q. Form Q must be sent 4 copies and ensure 1 copy of it is original. So one is original and another 3 is photocopies. The form Q not be attached with other document. The form Q just form Q. Okay, then form Q must include date and amount tax payable, containing additional information, and be signed by appellant. That means nobody can sign the form Q. Even tax agent or lawyer cannot sign the form Q. If the form Q not complete, the LHDN will return to the appellant. So next is form N. Form N is for late appeal procedure. This form for extend the appeal time. Give the appellant should give good reason to extend the time. Example like hospitalist for a long time, absent from country. So he should give the reason to the LHDN to extend the time, because in form Q, the time just only 30 days. But if he already passed the 30 days, he should send form N to LHDN to extend the date. The form N should be sent to the branch office of IRBM. This form N not like form Q. Form Q send 4 copy. This form N send 2 copies and 1 of is original. 1 of is original and 1 more is photocopies. If application to extend is approved, IRBM shall issue form CP15A. Okay, CP15A is for advising the applicant extended date filing date of form Q, which is 30 days from CP15A date. That means this form is for to get the time to fill the form Q back. Understand? Then if extension of time is not permitted, that means not approved, form N will be forwarded to the SCIT together with a statement of the reason for the DJIR denial. You should give the statement of the reason why you should extend the time together with the form N to the SCIT. Then after the DJIR After that, DJIR must inform the appellant, provide a copy of statement of reasons together. Then, appellant should make a written presentation to ACIT within 21 days of receiving notice. So, the appellant should make a written presentation to the ACIT for the reason why the DJIR should extend the time for appeal. Within the written presentation, that written presentation must be due in 21 days of receiving notice. Next, for Dr. error cases for appeal, for his cases, he don't need to use any form for appeal because he not send his statement yet to LHDN. But in case if he send the statement or assessment to LHDN, but LHDN do mistake to the assessment, so he can make appeal using form Q. Then next case, if the things he should get but LHDN not give to him, example like relief, he already put that relief in his assessment, but LHDN reject it. Okay, but for if he want to use form N, the first appeal 30 days using form Q. When he pass the 30 days, he can use the form N to appeal to extend the appeal time. Okay, that's all for me. Thank you.